This is Michael Popok for the new Legal AF MTN channel. I wanted to talk about and break down for you the 180 pages plus, probably hundreds and hundreds of pages more, that Jack Smith, special counsel, breathlessly filed the dirty bomb against Donald Trump in the DC election interference case that was due yesterday. So why aren't you, Popok? Break it down for us like we come to expect on the new Legal AF MTN channel. It's because he did file it, but it's all under seal for now, subject to review by Judge Chutkan. So let me tell you about that procedure, what we should expect, and when we should expect to see a version of the 180 pages with a lot of black lines on it and why. And if ever those black lines come off, and how they come off over the course of a criminal trial. Let's break it all down for you right here on Legal AF MTN. Okay, short answer, we didn't get the 180 pages. It's under review by the judge. The judge is working, it's almost like a workshop, with the lawyers on both sides to come up with a version that's proper for public consumption. What do I mean by that? It has, by its very nature, certain aspects that go to our national security. It goes to the office of the presidency, is top secret, is classified, and is sensitive enough that it shouldn't end up in the public purview, especially before the case goes to trial and we pick a jury. You don't want to corrupt the jury, blow their minds in advance with a full display of everything, and including an airing of evidence, which apparently is going to be done. So she, Judge Chutkan, has to balance, because she is the chief administrator of justice in that courtroom. And whatever decision she makes now about what gets released to the public and doesn't get released to the public, that's not going to be appealable. I'm not going to be reporting on any attempts by Donald Trump to go run to the DC Court of Appeals because they don't like the way Judge Chutkan used the redaction tape, or how she used her black magic Sharpie marker to underline. That's not happening. It's within the firm. It's given to the firm discretion of the trial judge. And no one had to do her job after 15, 16 years on the bench, and a federal trial lawyer before that, is trying to balance working with the two sides. The publics need to know, because the public has a seat at the criminal justice table in our system of government, our system of justice. We don't have secret trials. We don't have star chambers. People don't disappear in the middle of the night, never see the light of day unless they're in Guantanamo. Are not given due process, aren't given lawyers, jailed forever. I mean, there are certain circumstances, especially in some states, where some pretrial detention happens and people can kind of get lost in the system. But generally, we don't do that. And the public has a seat at the table. What I mean by that is we have the right to know about the criminal prosecutions of people, investigations, whether they were cleared by a jury, indicted by a grand jury, convicted by a jury, whatever it is, we have a right to know, right? Sunshine is the best antiseptic. And we like to have a lot of sunshine and transparency in our major pillars of our constitutional republic. So the judge has to balance that against not injuring or prejudicing the defendant, who has to eventually pick a jury, even Trump, a jury of his peers in the District of Columbia one day. So if you give out too much information, right, you got to calibrate this right. If the judge gives out too much information in the publicly filed on the docket, the list of electronic documents in a case, too much information blows the mind of future jurors and turns animus towards and heaps animus and scorn on somebody, Trump, who is presumed to be innocent. So she doesn't want that to happen. If you release too little, it's just a giant piece of black, like the Pentagon Papers, just black paper, blacked out. Well, that's not our public justice system. So that's the calibration she's doing. I'm sure in certain circumstances, Trump's lawyers are fighting for more redaction, more blackout. In some circumstances, I'm sure they're fighting for less redaction. We like that fact. We like that allegation. Let that come out. I'll use that on the campaign trail. Government is probably more agnostic about it. They want the judge to be able to do her job. They want, and there's certain things they're going to say, Judge, that's classified, that's top secret, that's confidential at this point, and they'll make the argument. So the government will make that argument as the adult in the room. Trump will make crazy, high chair throwing food arguments, and the judge is going to have to be the final arbiter, and she will be. That's the process we're waiting for. So the deadline was met, and now over the weekend there's going to be a process. So somewhere between this hot take and early next week, maybe even by the time the hot take is over, we're going to get the 180 pages, but it's going to have a lot. It's going to be like Swiss cheese. It's going to be a lot of holes in it. But, let's be frank, with good reporting, and some access to things like the Jan 6 committee report and other filed indictments and other cases and other reporting, we can sort of piece together some of we can sort of peek under what's under the black tape. Or when they name people, unindicted co-conspirator blank, oh, that's Rudy Giuliani. Unindicted co-conspirator, oh, that's Boris Epstein. Oh, unindicted co-conspirator, oh, that's Sidney Powell. You could sort of, with the body of work that we've developed on Legal AF, that we bring to you here, and in my mind, I can sort of piece these things together along with my research and analysis. And I'll do that for you when I get my hands on it, which should be relatively soon. I mean, again, public justice, we don't let these things sit forever. It's not unusual, by the way. In courts that aren't even in the criminal world, like in Delaware, which handles all of our business disputes because mostly corporations are incorporated in Delaware to get the benefit of Delaware law and Delaware court system. The Delaware Chancery Court, which handles all that, anything you file there is automatically sealed for at least 3 days to let the parties work on a redacted version of commercially business-sensitive information. So this happens all the time. And judges are pretty adept at it. It's a skill set they have to have. And we know Chutkan has a very good skill set. Now, she'll make her initial decision. It'll be somewhere probably leaning more towards the Department of Justice's recommendations. And then we'll get our hands on it. And we'll be able to give you a lot of information and analysis at the intersection of law and politics using our best professional judgment right here on Legal AF MTN, on the Legal AF podcast and the like. And over time, there'll be new versions with less and less redaction on that document. We'll be able to do more and more analysis and reporting. What do I mean by that? When we get to trial and things end up in the public domain, she'll be able to rip the black tape off of certain allegations because it's already out there. And what will keep her honest, so to speak, is that the news media, with their First Amendment rights, are going to be filing motions to get more and more of the document. And so that tension, which is a good tension in our constitutional republic, in our checks and balance world, in our free speech, freedom of the press, it's a good thing. It keeps the Department of Justice and the justice system humming and spinning in the right direction. So over time, maybe after events in the courtroom become more public, as we get to the trial, you'll see more and more comprehensive, more fulsome, until one day after a jury has ruled, we'll see the full version, and we'll watch it along that continuum. So come back to and free subscribe. We're trying to get to 200,000 subscribers before Halloween. We're already halfway there after just 10 days. We're 10 days old, everybody. I mean, we're a 4.5-year brand in Legal AF, but we're 10 days old as our own channel in collaboration with Midas Touch Network. Free subscribe. Maybe you missed out on the build at Midas Touch Network to get to 3 million. Help us get to 200,000. You'll remember where you were when you hit the button for free subscribe. I promise you, I'll remember where you were. So Legal AF MTN, at Legal AF MTN. Tell your friends and family, people in your life, come over here and find out what 40 million people a month already know. That Legal AF is the home of law and politics commentary and analysis like no other. And I'll be doing a lot of my work here, curating this channel, putting together those stories at that intersection of law and politics that you've come to enjoy and respect and rely on, in addition to my work on the Midas Touch Network, the main channel, and Legal AF, the podcast, being over on the main channel. Follow us on Wednesdays and Saturdays at 8 p.m. Eastern Time over there for the YouTube channel, Midas Touch, for Legal AF, and wherever you get your podcast from. So until my next exclusive content right here on Legal AF MTN and the podcast, this is Michael Popok reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.